Your original hometown dealer, Saida, Trudeau Chrysler Jeep Dodge and Ram.
Deutch was convicted in a bench trial of domestic battery and injury to other property less than $25 after being arrested and charged in September of 2018 for slapping his then-girlfriend on the buttocks. At the time, he was a first sergeant with the Nye County Sheriff's Office. Deutch was sentenced on the first count to $340 in fines, 2 days in jail that were converted to 48 hours community service, an additional 48 hours of community service, domestic violence counseling, and 90 days suspended jail time. On the second count, the court imposed $355 in fines and fees and restitution. Because of the guilty verdict for domestic battery, under federal and Nevada law, he is prevented from carrying a firearm. This made him unable to continue his career in law enforcement. Deutch and his attorney, John Aldrich, were in court yesterday to argue for a new trial by jury and appealing to amend judgment of Deutch's conviction. Judge Wonker reviewed the history of the case from conviction in October of 2018 to the appeals that were presented yesterday. Aldrich opened his argument by saying that on December 22nd, a motion was sent to the court asking to be able to reopen the brief on the appeal and to be able to add information. Judge Wonker said that the defense had done the same thing in 2019 and she denied the reopening. She said that the law is very clear as to the role of the district court judge on an appeal up from the Justice Court. They cannot take any new evidence. They must use the record on appeal. No new facts or evidence may be added. Judge Wonker said she read the transcript from the prior appeal and it was hers to determine if there was an error of law or whether there is substantial evidence in the record to support the findings of the Justice of the Peace. Judge Wonker said that there was sufficient evidence in the record to support the determination of the Justice of the Peace. After hearing arguments from the state and the defense, Judge Wonker came to the conclusion that there was a procedural error that prevented the district court from having jurisdiction. It all came down to dates and the letter of the law. An appeal was filed on November 6, 2019. The law says that a defendant may appeal only from the final judgment of the Justice Court. The defense appealed from the verbal pronouncement of the record. The written order denying the defendant's motion for a new trial was issued on November 22, 2019. Wonker said that the appeal was filed premature. The court has jurisdiction from the final judgment, the final written judgment, after it is filed by the court's clerk. Judge Wonker said that as far as she is concerned, the motion for a new trial is not before the court because the court does not have jurisdiction to hear the issue because the appeal was filed before the final judgment was entered. Addressing the amended judgment of conviction, Judge Wonker said that it was too late to appeal because the appeal had already been heard and decided and remanded to Justice Court. An appeal for the amended judgment of conviction was filed on July 6, 2020. This fails because the appeal must be filed within 10 days and it had been at least 30 days. Judge Wonker again said that the appeal was untimely and she ultimately denied both appeals.